areas of practice or about vocational potential in the legal arena, we instinctively advert to a certain level of compartmentalization. We talk about litigation as we know it. We then juxtapose it with, say, a corporate law practice. We juxtapose it, say, with academia, policy work, the judiciary, and so on and so forth. Within this overall identification of litigation as a vocation, the lines between the different modes and types of practice are largely blurred and fall within the overall rubric of dispute resolution. Now, such an approach is not exactly incorrect, in the sense that a litigating or disputes resolution lawyer is, of course, required to handle the entire scope and ambit of the process, from the earliest days of advising the client on a potential future litigation to drafting, to filing, to arguing, handling the appellate stage, execution, and so on and so forth. Now, in this broad framework of how a case progresses through our legal system, one can deduce two distinctive skills at work in the entire process. That is drafting and oral argument. Now, both of these elements in conjunction with each other are very crucial in achieving the desired ultimate goal, which is of convincing the judge and ensuring victory for the client you represent. Now, in this sense, both aspects are equally important, and it is not correct to postulate a hierarchy between them. But be that as it may, respect for all elements of the practice need not blind us to the different skills at play in these distinctive fields. Now, just like in the case of culture, an appreciation of the essential difference between these two, that is drafting and oral advocacy, is crucial for us to be able to engage better with the nuance, richness, and potential that they both offer. Now, in the context of today's discussion, this difference is also important to appreciate in the vocational sense. For those practitioners who find an interest in and a desire to specialize in the latter, which is oral advocacy. Now, we all know that two factors are essential for an advocate to present a winning oral argument. Obviously, a thorough understanding of the law, and more crucially, the ability to present those arguments in a manner so that the response which is actually required or desired is then received from the person who is being addressed. So along with research, persuasion is critical. Now, examples of famous oral arguments and summations abound both domestically and around the world. I always remember how in a denaturalization case involving grave constitutional issues of citizenship, a lawyer started before the US Supreme Court with the words, the issue is whether a good Nazi can be a good American. So, it's so concise, but carries that point so effectively, as also, the rhetorical value. Now, why is this so? So Justice John Harlan, again, a judge of the US Supreme Court, pointed out that many judges listen better than they read and are inherently more receptive to the spoken rather than the written word. Now, this is exactly why oral advocacy is so important in our system of legal adjudication. Now, Aristotle in the 4th century in his book, The Rhetoric, had defined certain, foundational aspects of what constitutes effective persuasion. So he said that, one must discover in the case which one is representing the available means of persuasion in the context of the speaker, the subject of the speech, the person being addressed, and as to how the object of the speech must always be determined by the audience. Now, all of this sounds as simple as it sounds inspirational, but how exactly does one get there? How does one hone these specific skills? More importantly, because one learns only by doing. And how does one therefore generate and develop an arguing counsel practice at an initial stage? How does one approach a practice built around oral advocacy? And what are the investments, both knowledge-based and infrastructural, that one needs to make in this endeavor? Now, we have a very distinguished speaker here today who will be addressing us on precisely these aspects. Mr. Sibal, as we all know, is a senior advocate practicing before the High Court of Delhi. He was designated senior advocate by the High Court in the year 2017, at which point I'm told he was one of the youngest ever to be conferred with this honor. And for many years prior to his designation, he had an exclusively arguing counsel practice. So not only is he perfectly equipped to speak on the topic, his experience in this regard as a young lawyer in attempting to, and eventually succeeding in building up a flourishing counsel practice is also very contemporary. I'm sure we will all learn a lot from hearing him speak of his experiences. Now, I would like to thank Mr. Nitesh Mehra, Mr. Angel Bharadwaj, and Mr. Anand Garg for having me over. Now, back to you, Nitesh.
Sorry, Nitesh, we can't hear you.
What do you say?
Right. Thank you, Nitesh. Thank you, Amit, for those generous and warm introductions. And thank you, Amit, for the very erudite and insightful remarks on the topic. Let me jump right into it. I'll focus today on two phases of developing and arguing counsel practice. Firstly, the initial early years when you're starting off till you're able to slowly begin your practice as an arguing counsel. And thereafter, secondly, consolidating and expanding that practice with designation as a senior advocate being the goal. So let's start from the beginning. Where do you start? Do you join the chamber of a big name, a super senior? Do you apply to a big firm? Should you start out on your own, perhaps with another colleague? Should you begin with the district courts, the High Court, or the Supreme Court? There are many possible approaches. The first thing to remember is that there's no one right approach. There's no formula. Each journey in the profession is a unique one. A trajectory that's worked for one person may not fit another. So the idea is that you need to find something that suits you, an approach that allows you to learn in the way that you need to, while focusing on work that you enjoy. Look, each person's preferences will be different. But having said that, let me try to share with you some thoughts that might help you to think about how to structure the early years. Although starting off with a super senior, if you have that option, may sound quite attractive, there are certain disadvantages. It's exciting, it can be very motivating, especially in the beginning. You know, you will probably be associated with high profile litigation. The matters you're involved with may feature in the news. You're going to be excited to share your involvement with people at home. Perhaps your name will feature in the news report. But I tend to believe with a senior of that standing, you're mostly as close to the action as you're going to get without really being a part of it. Why do I say that? Well, at that time in the beginning, you're very raw. And the senior you're working with would have put in maybe over 30 years in the profession. So the gulf between the two of you would be substantial. And so the ability to relate at a professional level is not going to come easily. It's likely that the senior will be extremely busy and the time for interaction that you have at an individual level will be extremely limited. Your involvement is likely to be mostly to attend conferences with a large number of people, various solicitors. You'll be struggling to maybe make some limited contribution in the conference. You'll look up some law separately, flag some pages in the file for the senior, and help her with keeping track of the case, which case is reaching in court. But you're only going to have a superficial understanding of what's going on. It's unlikely that in that environment, you will face and tackle your weaknesses. You won't be doing any drafting. The briefing will primarily be done by the solicitors who have engaged the senior. At best, you'll be making a summary note for the counsel. Of course, you will be in the company of greatness. You will witness extraordinary court craft. You will begin to notice the challenges of arguing in our courts, but you're not going to really experience or understand it in a way that allows you to learn that craft. No one will explain it to you or teach you the method. And because that gulf is so great, you won't be able to decode how your senior is thinking. And after a while, what tends to happen is that the instructing advocates are chasing after you because you become an access point for the senior who's not otherwise readily available. So you become a go-between, a messenger of sorts. At times, you might even receive a second brief in the matter from the instructing advocate. He might ask you to charge an independent fee in the matter. But that'll primarily be because of your association with the senior, not in your own right. The instructing advocate will want you to be invested in the matter in the hope that you'll help ensure that the senior will reach for the matter and be more committed to the matter. It's not a great role, frankly, to play professionally. Of course, you can learn a great deal from working closely with a senior of that standing. And there are many, many exceptional counsel who are products of a super seniors chamber. But perhaps it's better to join such a chamber at a somewhat later stage, after you've put in a few years, once you have a better grasp of the basics, so that you can at that stage follow and contribute and learn more effectively. Now, what about a law firm? Good part with a law firm is that you can get exposure quickly to all aspects of litigation, how the registry functions, how to draft, briefing seniors, interacting with clients, and putting together the case from scratch. Also, there'll be people of your own age group and level of experience. There'll be others who you can look to for support and guidance. Usually, there's an infrastructure in place that you can easily have access to and use to get things done. But there are significant drawbacks. A law firm in the end tends to function as a business. It's all about numbers. So you're usually overburdened, overstretched, you're simultaneously fighting many fires on multiple fronts, and everything tends to be last minute. You're drafting, you're overseeing filing and listing, you're traveling halfway across town to brief seniors. You're spending a great deal of time on logistics. And what that means is that you're going to have very little time and mental space to do quality work. Look, what we do requires thought, care, reflection, discussion, debate. And in most firms, the environment and the pace of work is such that it's just not conducive for that. Also, people's experience in firms, I found, tends to be uneven, especially in your earlier years. The interaction and engagement with more senior partners can be very limited. You tend to work under a senior associate who, might well be taking out her frustrations on you. So it can end up being a negative environment that doesn't suit everyone. My recommendation would be to spend 1.5 to 2 years in a law firm in the early years, at most, maybe 3 years. That's more than enough to learn the basics of drafting, how the system works, get some exposure to briefing seniors, and perhaps to different courts. But it doesn't have to be a big firm. You can join a smaller partnership if that appeals to you more. And it's possible that in a smaller outfit, you'll get to shoulder greater individual responsibility right from the beginning, which can make for quick learning. So the idea is spend a couple of years somewhere that will expose you to drafting and the basics of the litigation structure. Look, drafting is not rocket science. There are templates, formats to help you. You don't need more than a couple of years to understand how to go about it. Once you know the basics, your drafting ability will really only develop as you develop as a counsel. Ultimately, it's those who argue in court and deal daily with pulling apart pleadings who are the best suited to spot the problems with pleadings and therefore to identify what needs to go into pleadings. You must think like a counsel to be a good draftsman. So in the initial years, you only need to learn the basics and get some practice. Once you understand the mechanics, your ability to deal with content will develop as you develop as a counsel. And a firm is not the best place to grow as a counsel. For that, I feel ultimately you need to join the chamber of an arguing counsel. So joining the chamber of an up and coming counsel or a young senior is not a bad option, because since the counsel is younger, the gulf between you is going to be a little less. Your senior may still remember what it was like to be starting out and being at sea. The chances of individual interaction and learning are higher. So what you need to be looking for is to join a practice where you can develop your analytical skills and learn courtcraft. Ultimately, look, there's no substitute for arguing yourself. And any learning will be limited until you get up there and argue yourself. But the next best thing is to learn to think, to formulate, to rehearse arguments in your mind, and to watch and understand someone else's process so that you can use that as a template to develop your own method. But for that, you need to be in a place where you have an opportunity to understand the process. With a super senior, the problem is that you will see the machine at work. You will experience its phenomenal output, but you'll be left wondering how the machine converted X input into Y output. You're not going to understand that process of conversion. For that, you need to be able to observe every step of the machine's working. You need to be able to remove the exterior casing and look inside at how the parts fit together and work together to yield a particular result. So you should be looking to join a place where you can have a more intimate insight into the legal method that goes into counsel practice. And you need to work with someone who will engage with you, guide you, and mentor you. If you join somebody too senior, too busy, you're unlikely to find that. Now, ultimately in this profession, there's no getting ahead without extreme hard work. And it's not easy mechanical work. It's not just about putting in the hours. It's about constantly reflecting and making that time effective and productive, and doing it under pressure with difficult timelines. So if you're going to put in that kind of effort and you're going to allow it to take over your life, which it will if you're committed, then it had better be enjoyable. You know, there's this attitude we have in India that suffering makes you stronger. And so it's okay to be put through the mill because you're going to emerge hardened and ready for the big bad world. Personally, I'm not a big believer in this philosophy. Hard work, yes. Sacrifices of personal time, of course. But it must feel worthwhile and enjoyable while you are doing it. Not for some indeterminate, distant reward to come later, but right then and there. I can suggest to you some relevant aspects to consider while you decide how to proceed in your career. But only you know what's a good fit for you. I can't tell you that. And you must be honest with yourself about it. You know, don't simply be the version that somebody else expects from you. Don't blindly follow advice on whom to join and how to start out. Learn to exercise your own judgment after considering your personality, your likes, dislikes, your temperament. Don't just try to fit a precast mold. Independence of thought and action are qualities you must learn to develop early. They're essential for a successful counsel practice. Let me share something with you on a more personal note. So I studied at a college in the US. That was my first degree. And I remember in the first few weeks there, I was living in campus accommodation. And the other students living in the same place, they would ask me, you know, why did you choose this college? And my only answer was, well, it's a renowned institution, it's a top university, and I got in. And of course, my parents approved. Frankly, for me, there wasn't much else that went into the decision. But I realized from speaking to my peers that the American students had a very different approach. Uh, Most of them, almost all of them, had visited the campus, looked into campus life, thought about the culture of the college, its political leanings, if any, and of course, taken into consideration its academic credentials. But not only that. And based on all these factors, then decided whether it was a good fit. But as Indians, that's not how we think about things. Our academic approach, our cultural approach, the way we're brought up, it's not about individuality, it's about conformity. And at times that holds us back. So don't downplay your individuality, recognize it and develop it and factor it into your decisions. The reason I feel this is important is because you will enjoy your work only when you do that, when you make sure that it's suited to your likes and dislikes and your individuality. And when you enjoy your work, you will excel. You need to be passionate about what you're doing to be able to push yourself in that way. If you're going to see it as a job, as a chore, if you stop thinking about your cases once you leave the chamber for the day, then you don't have that interest and passion which you need to instill. And if you're honest with yourself, you will know fairly quickly whether the work that you're doing and the person you're working with is a good fit for you. If you're not enjoying it, make a change. Course correct quickly. Don't spend time suffering and waiting for it to get better and for that reward to come. Now, don't take me as suggesting that you shouldn't give things a reasonable chance of settling down. Of course, you shouldn't act rashly, but don't let unhappiness linger. Address it and resolve it. Find the work and the workplace that suits you. Now, I said earlier, there's no substitute for arguing yourself. So obviously, from the very beginning, you should be looking for any opportunity to argue. But initially, those opportunities may be hard to come by. If you can join someone where you can both get that learning you need and also get the occasional arguing opportunity, well, nothing like it. But of course, that option is not so readily available. So what you need to be thinking about is how to create those opportunities. If you gain the trust and respect of the solicitor and the client, they may instruct you to argue in a case when your senior doesn't reach. For that, you always have to be ready to argue, because that opportunity is not going to announce its arrival in advance. It's going to present itself with a moment's notice, and you'll need to rise to the occasion. It's tough, always being ready to argue and almost never being called upon. But I assure you, even that preparedness is the second best kind of practice and learning. So it's never going to be wasted. Because if you're fully ready to argue, if you've structured your thoughts, then even if you don't get that opportunity, you will be able to contrast your approach with that of the counsel who actually argues, and you'll be able to better absorb what worked, which argument missed the mark, and you're going to begin to understand why. So my advice, always be ready to argue. Now, what's the timeline on all this? Well, ideally, I would say you should move towards being independent within 3 to 5 years of beginning your practice. At most, 5 to 7 years. I know it sounds ambitious, but beyond that, you'll be losing valuable time, because you'll need at least about 10 years after you start counsel practice in earnest to make a mark and move towards seniority. So you're looking at an overall timeline of at least about 15 years. Now, many people ask me about whether they should go abroad for an LLM, do a master's in law. I know that with the current scenario, that's not going to be a real option in the immediate future. But things will change and hopefully normalize in some time, and those options will hopefully become available again. Now, I don't think the legal learning in an LLM per se will be a game changer or a great value addition to your counsel practice in India. It's certainly not going to hurt. There will be some learning, of course. But if you've not already had a chance to study abroad and it is affordable to do an LLM, I would recommend it. It's not so much about the academic learning itself, it's about the experience, a different environment of learning, a different varied peer group, a different exposure, which ultimately expands your mind, your perspective. It creates an elasticity of thought that's otherwise a little difficult to develop. And it makes you less insular. It brings a certain maturity and independence. And that's always going to hold you in good stead. Okay, so now you're independent. How do you develop your counsel practice? Initially, most people will file and argue their own cases. It's difficult so soon to be briefed by other lawyers to argue. But you should try to move towards that, because if you only argue the cases that you file, then other lawyers will see you as competition, other filing lawyers, and they'll be unlikely to brief you. They'll worry that if they bring you into the matter, you might take away the client. So over time, you need to position yourself actively as an arguing counsel and not as the advocate on record. Being both ultimately detracts from your status as a pure arguing counsel. One of the things that I would do, and I'm not saying this is straight away possible for everyone, is that the client would come directly to me. Now, the client didn't care if I brought someone else on board. He was willing to pay a certain amount of fee. How that ultimately got divided didn't matter to him. He said, look, this is my budget, this is what I can pay. So I would request someone to come on record and take care of the filing. I would do all the substantive work, but the other lawyer would take the responsibility of filing and being on record in the matter. And for that, I would ask the client to reduce my fee and pay the remaining part to the other lawyer for his contribution. We would, of course, appear together in the matter, and the other lawyer would be my instructing advocate, and I would be the arguing counsel. And that's how I started from the beginning, to position myself as a counsel. And along the way, of course, helped a few junior lawyers as well. Now, becoming independent, is always challenging, and it's going to require some risk appetite. But then whenever you do it and take that decision, it's always going to be a bit of a leap of faith. So better that you do it early before your financial commitments increase too much and you get cold feet. The initial phase is bound to be tough. You'll see your peers working with seniors, coming to court every day, being busy with several matters, and you won't have matters for court on a daily basis. You'll be waiting for something to come along. But don't worry, give it time. Your colleagues may be busy, but ultimately they're busy with other people's work. Your work, even if it's much less frequent, will be your own, and you will naturally be committed to it, and the reward will be far more fulfilling. I remember facing the same concern early on. I remember sharing that concern with my father, and I recall him telling me that the amount I'll learn and the satisfaction I'll gain will be far greater from a matter that I have seen from inception to conclusion, possibly through various stages of appeal, which is my own matter, as against the several matters that my colleagues are assisting their respective seniors with. And he was right. I used to have maybe 1 or 2 matters in 2 or 3 weeks when I started out on my own, which I did from the very beginning. But it got better. I went after every arguing opportunity that I could, whether it was paid or unpaid. And in time, slowly, people began to take notice. And that's ultimately the only way to go about it. Someone will see you argue, He'll be impressed. He'll send you a brief. How that practice takes off, when it does, there's no science behind it. And the timing, the trigger, they're different for everyone. So what I want to tell you is, don't be disheartened if the going is extremely slow at first. Stay the course. The few matters you have, put your heart and soul into them. They'll certainly lead to further opportunities, which over time will increase exponentially. And once you hit that minimum threshold, then you'll never look back, because after that, the multiplier effect will kick in. Okay, so now you've started a counsel practice. What are some of the things to remember to help you grow as a counsel? Firstly, you're in the business of persuasion of a human being. For that, you must try to understand the mindset of that human being. Surely, when you try to persuade your father, mother, sibling, significant other, you use different approaches depending on their respective personalities. So it's the same with judges. I used to spend almost all my waiting time in court, going from one courtroom to the next, carefully observing arguments, arguing styles, reactions of the judge, and trying to get a sense of the judge's courtroom personality. It's an invaluable learning. Remember, to win the argument, you need to win over the judge. So don't follow a one-size-fits-all approach. Modulate both the content of your argument and your style of presenting it based on the judge. You'll get a sense over time of where the judge's heart lies, and that is the safest route to her mind. I remember when I had a matter before a judge before whom I'd never appeared before, I would go a couple of days in advance and sit in her courtroom and observe. And so 2 days later, when my matter was listed, I'd be much better prepared for my appearance, because I'd have a sense of what's the decorum that the judge insists on, what's the line of argument that she likes, what's the manner that she's comfortable with, and so on. Remember that over time, what you build is your reputation and credibility, both with the court, with your colleagues, and with clients. I recall my father telling me when I started that your greatest earning will be your reputation. So try not to jeopardize it. Ultimately, it's that credibility which will play a pivotal role in your ability to persuade and secure orders favorable to your client. Once you do something to undermine that trust and credibility that a judge reposes in you, then you lose the judge and the case. So don't make the mistake of acting only for a short-term gain. You may win the case, but lose the trust of the judge. Always play the long game. As a counsel, remember, you're not a puppet of either the instructing advocate or the client. You're first an officer of the court. But yes, be kind to your instructing advocate, because that's where your matters come from. Generating goodwill by helping others and supporting others. That's not only the right approach, it's a strategically smart one, because grateful advocates stand by you and support you over time. As a counsel, your work comes from other advocates. There are times when you need to stand up to a judge. Sometimes a judge is being plainly unfair, and you need to respectfully, while observing decorum, point it out. As a counsel, you shouldn't be groveling and obsequious. Our system does encourage and reward that. But frankly, in my view, you build mettle and develop character by standing up for what is right. You can't always persuade a judge. Make your point, be firm about it if you need to, but don't get upset merely because the judge disagrees with you. You might be convinced by your argument. The judge has a right to be unconvinced. You shouldn't take that personally. Soon after I joined the profession, my father joined the government. So I would hear from others about his courage in court. I remember sharing my hesitation and anxiety with him about standing up to a judge. And he advised me that You should only do it if you're 110% sure that you're in the right and not otherwise. And that doesn't mean being disrespectful or picking a fight with the judge. It only means that you politely call the judge out on something that you believe is improper. Judges are also human. They're fallible like the rest of us. They're not gods, and you don't need to be afraid of them. You'll also face much more senior counsel on the other side who are going to try to bully you. They may make patronizing personal remarks about young men in the profession who need to learn. Don't get distracted. Don't let yourself be bullied. The answer is not to get aggressive. A bully wants to provoke you. And if you get upset and rattled and you lash out, then unfortunately, the judge is likely to haul you up and not the senior on the opposite side. Is that unfair? Of course it is. But you have to deal with it. It's the disadvantage of being a young counsel. And the best way to deal with it is to not engage in personal crossfire. Simply make your argument with confidence, with clarity. Try to outdo the other counsel with your knowledge of the case and the strength of your argument. I assure you, the judge will respect you more for it. And don't worry about the peanut gallery, which are the other people waiting their turn in court who are happy to snigger at your expense. Don't let it affect you. Block it out and proceed with your argument. So long as you know your case well and you stand your ground with confidence, not aggression, you're going to be fine. As a counsel, you should only make credible arguments in court. Don't agree to argue anything and everything that your instructing advocate wants you to argue. At times, I get a brief where I see no arguable point. I don't mind making a weak argument. Sometimes that's the hand you're dealt. But there needs to be an arguable point. If I feel there isn't one, I return the brief. Every time you make a hopeless argument in court, as if it's a convincing one, you undermine your credibility as a counsel. A judge should always take you seriously, and that won't happen if you make obviously untenable arguments. You must learn to anticipate the reaction of the judge. And for that, you need to be objective about your case by imagining what your reaction would be if you were the judge. Look, the client is rarely objective. The instructing advocate also tries to push the client's perspective, especially if the client is present in the conference or in court. So the burden falls on you to be objective and to decide how to pitch the case in a persuasive manner. It may at times require conceding the weakness of your case at the outset and then trying to press a different point. Everyone has a different style. I prefer to be blunt about what I believe to be the merits and demerits of the case. One shouldn't be overly negative, but holding out false hope to the client can backfire if you later don't deliver. Sometimes it's not what the client wants to hear. Occasionally, the client may decide to brief someone else because they feel that you're being needlessly negative. That's okay. But I believe in giving honest advice and a candid evaluation. If everyone just tells each other that it's a great case when it's not, then you don't work hard at overcoming the weaknesses, at anticipating what the opposite counsel will argue in court against you. And the client then feels shortchanged when the proceedings don't go his way. If you, on the other hand, prepare the client for a more realistic outcome, then the client is better prepared for a possible negative result. Now, I want to end by emphasizing that a counsel has to constantly exercise judgment and make choices and lead from the front. Sometimes it's knowing what not to argue that gets you the order. So please be fierce about learning to think independently, about honing your instincts. Don't worry about making mistakes, and don't be easily disheartened. As Mr. Fali Nariman says, this is not a profession for the chicken-hearted. But if you have the courage and the stomach for it, counsel practice is truly glorious and deeply gratifying. Thank you all.
Thank you, sir. This wonderful session. Now I request Dr. Anand Garg to take it home from here and see that kindly ask it on behalf of the viewers and the participants. Mr. Anand Garg, over to you.
Hello. I hope, sir, you can hear me.
Yes, I can, Anand. Thank you.
Sir, first of all, thank you very much for this session. It was a pleasure to listen to your personal experience and a guidance to all the juniors really wants to enter into this practice. I think, sir, honestly, you explained it so well. I don't have any questions to ask, but I just really want to have one question. In the current scenario, where now the most of the proceedings are going through video conferencing, and honestly, I don't see that for coming months, the courts may able to resume the normal working. So, as the arguing counsel, do you think it's an opportunity or it's a hurdle?
So I think that for younger counsel, it's a great opportunity because the old school counsel, the more senior counsel, for them, adapting to this technological change is that much harder. And
Sorry for disturb. Please tell me Hindi.
I'm sorry, please maintain the silence. Whatever your questions you have, kindly put it in the chat box. Let's not interrupt the session in between. I'm so sorry for interrupting.
no,
So sorry, sir.
not at all. So I think that this is a great opportunity for younger counsel, to be able to match the more senior counsel and, perhaps with their greater proficiency with technology, outdo those counsel. And there's another aspect as to why I feel it's an opportunity. That gravitas which a counsel carries with her when she comes into court, that presence, that very frankly is somewhat reduced in a video conference, in a virtual hearing setting. There's also tends to be a greater necessity of maintaining decorum, and the judge tends to insist more on people arguing at their turn. So therefore, for a well-prepared younger counsel, you'll have your turn and your opportunity to present your case free from that interference, that outshouting that sometimes takes place in court, and that sort of possible bullying or throwing one's weight around. It's a little bit diminished in that virtual hearing setting. So I think that it's a great opportunity for those on the younger side who are technologically much more capable.
Thank you, sir. Hello. Nitesh, I think there's something technical glitch. Hello.
Yeah, I can hear you.
I think somebody has started. Sir, then there is another question from one of the viewer. How do you, being an arguing counsel, you get so many briefs for a single day? So how do you manage balance between all the briefs you get sometimes you get 5, sometimes you get 10. So how do you manage all that matter?
That's a very good question, and it is a challenge. So I follow a twofold approach. Number one, I've always tried to sort of limit the number of matters that I take on to what I feel is manageable. So I have, it's not dependent necessarily on numbers. It's dependent on what those matters are coming up for. So you can have greater numbers if none of them are for, substantial arguments. But if even 1 or 2 of them are for substantial arguments, maybe one of them is part heard, then obviously your ability to take on another heavy matter becomes reduced. And it's tough, because your colleague, your friend, the instructing advocate who brings matters to you, that person wants you to just say yes. They'll say, no, 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 please accept the brief. It makes their life much easier. And it's difficult to say no to your friends, in the profession, and to refuse a brief and say, no, I already have too many matters. I can't take on another matter. But I can tell you that solicitor, that instructing advocate may face some disappointment and feel some disappointment when I say no. But over time, they understand that, look, I'm only saying no because I want to be there for all the matters. And they also appreciate that I'm not taking on a matter that I'm then going to most likely miss, because that's far worse, for that solicitor. So therefore, I think people do understand, and I have found, and I'm grateful for it, support and understanding with that sort of approach. Secondly, of course, it's very important for whichever matters you've taken on, even those there are clashes, there are conflicts. So it's very important, and I always tell my juniors this also, that you must have a sense of the list every day. And if you see the counsel who are sort of built in the old mold, you'll see some of the old school counsel, they'll actually even now carry a printout of a relevant page, of the list, the cause list, because they used to actually studying the list, even though, they're very senior counsel, and, they have more than one clerk to assist them and more than 2 juniors to assist them. But they'll still carry it, because it's important for a counsel to have a sense that, look, if one of my matters is listed before X, judge, what is that judge's list like? If it gets passed over, when is it likely to reach? Are there any other matters which are set down for hearing? So having a sense and an understanding of the list is very important. Don't depend purely on your clerk or on your juniors. Understand the list yourself, and then you can position your matters through the day more effectively, because you can take a call that, look, let me attend this one, get a pass over there, it'll reach in X amount of time. Of course, these are educated guesses. You go wrong at times, you do miss matters, but you do the best that you can.
Thank you, sir. Sir, then one of the viewer is seeking advice that if he wants to pursue this arguing counsel practice, what infrastructure do you advise that a counsel should have in his office in case he wants to go for arguing counsel practice?
So firstly, anybody starting out now is at a great advantage over what used to happen even when I started my practice, which of course is now, some time ago. But, technology in that sense has been an amazing enabler for, young lawyers who may not come from legal lineages, who may not have extensive libraries and space to store books and so on. It used to be the case that, those with that kind of infrastructure were at a great advantage, and lawyers had to, find, time to go to the library. They would be troubled when the library was closing. They'd make copious photocopies in the library, carry it home with them. But now all that, frankly, is available to you at the click of a button. I almost never use physical books anymore. I have many of them, thanks to my father having created a wonderful library, but frankly, I don't need it. I will go to commentaries from time to time. That does become important. But even a lot of them now you can find online. There are, counsel, I think Mr. Venugopal has made his library digitally available to people. So there are, ways to even access those things. So frankly, what you need is a place to meet your client, right? That's important. So you do need some space where you can sit, have, some infrastructure for that. You will ultimately, need a clerk. As a counsel, you will need some juniors. So you need some physical space for that, but you don't need extensive sort of physical libraries and books and so on, because that's all, available and accessible, electronically now. So I think that these are good times for young counsel to think about, their own practices.
Thank you so much, sir. So the last question which I really want to ask is, in case you have an interim order in your favor in a matter and you want to finally argue the matter, although is there any way that you can ensure that court should hear the matter finally? Because normally what the person we have from the court that normally we get dates, adjournments, the other side is interim. So is there any way that we can ensure that the court may finally hear the matter if you really inclined to argue the matter?
So it's
Being
the
arguing counsel, if you have any suggestion on this.
it's the tariq pe tariq problem, right? So look, there I can't give you an answer which will apply across the board, because obviously any suggestion has to be ultimately case specific, because it will only depend on the nature of the urgency. But ultimately, you need to think about, right, what ground of urgency can appeal to the judge. And for that, you have to sort of be objective. There may be an actual urgency which doesn't sound like a very appealing urgency in court. Remember, it's ultimately what sounds persuasive. So if the urgency that you plan to sort of tell the court is just that, my client is in a real hurry, he's facing some financial crunch, he wants an early resolution. Of course, for the client, that is the real urgency. He can't afford to keep paying lawyers and so on. But that's not an urgency which in our court is going to hold sway. So you have to find something, think about something on facts where you can persuade the court that this matter deserves priority hearing over others. Because what is in the court's mind is that, look, there's a long backlog. And if I allow it in case A, then why not in case B? What is so particular and special about case A? And no judge wants to give the impression that any one particular matter is getting preferential treatment. So you need to think, the question you need to ask is, how do I distinguish my ground of urgency from all other grounds of urgency in other matters which have been similarly deferred? Unless you can find that in your case, it's going to be hard. And on a sort of lighter and different note, there is a very strange absurdity in our system, which is that delay works as a precedent for further delay. So intuitively, if a matter is delayed and its consideration has been deferred several times, that ought to be a ground to persuade a judge to hear the matter. But in our system, that ends up being a ground for the judge to further defer the matter, because he says, oh, it's been pending for 4 years. Why not 2 months more? So it's a very strange, and troublesome aspect that the longer the delay, the greater the force of that delay as a ground for further delay, almost as a precedent. And that really has an inbuilt absurdity to it. But unfortunately, that's how it is. So it's a tough question. I wish I could give you, a fix for it. but this is perhaps how you can try to think about it.
Thank you so much. Sir, I think Angel Bhardwaj has some questions for you. He just there is something technical glitch is happening. Angel, are you there?
Yeah, Anand, thank you. Thank you, sir. I think what an
Hello.
interesting session for these, especially for the law students who are here. Am I audible, sir?
Yes, you are.
Yeah. So there are n number of questions. So let me get to them. There's one good question from Raghav. He says, I'll just say that whatever he's trying to say. He says, he has a continuous challenge that he face. This is the almost suffocating inability to translate all my thoughts and arguments that I built up throughout the night and prepare, but I'm not able to present the same thing before the judicial officer. So is it just a matter of experience, or a stage frightenness?
Yeah. So two things. Number one, you need to formulate your arguments very succinctly, right? And it helps to sometimes write out those arguments almost point-wise, right? And if you're having trouble, presenting it, the best thing is, again, to have a short note that you can refer to when you're in court, which has the relevant point, right? And what you can do is rehearse that at home. And I'm telling you, I used to do this. I was gripped initially by anxiety. And I would wake up in the middle of the night, in a sweat. And, my wife would ask me, what's happened? Why are you so troubled? And, she'd sort of pat me back to sleep because, and the reason would be, I had a case to argue 1 week later. These were my initial days, and I remember it. I used to be very anxious and worried, will my voice emerge? How loud should my voice be? Will I be able to articulate? If the judge asks me a question, will I freeze? How will I learn to think on the spot? So yes, I'm here to tell you it gets better. You do learn with experience. What I did to try to prepare myself better is I used to literally stand in front of a mirror and speak out my argument, right? I actually rehearsed it. Then I would go over it in my head again and again and do it as if you're arguing. And then over time, you will, get over your stage fright and you will be able to, articulate what you need to articulate.
Thank you very much, sir. Then there's another question from Zoya Mehta. She asks, how does an arguing counsel bridges the gap of knowledge about the facts of the case when being briefed by a briefing counsel? Is it all right to depend totally on the knowledge of the briefing counsel itself?
That's a very good question. And I'll give the short answer and then a longer answer. The short answer is no. You should not depend only on what's being fed to you. You need to look at the brief and think beyond the brief. You need to have a strong enough grip of the matter that you can actually pose some questions, possibly to the instructing advocate, to the client, elicit some responses, maybe facts which aren't part of the brief. That doesn't matter. You can worry about them not being part of the brief later, whether it's possible to introduce them by way of an additional affidavit in a further response. Firstly, you must think about how best to sort of identify the strength of your case, elicit responses. You need to, for that, go back to the building blocks of the matter. If you allow yourself to simply be led by what the brief tells you, and you don't revisit the basics, right? Revisit the facts from the beginning, and you just say, well, the instructing advocate has told me that these issues arise. Don't go by that. Look at the matter from scratch. That's what I used to do. Now, I relegate, I sort of divide the labor with my juniors because I may not have time for that kind of in-depth scrutiny always. But often I do that. I still go back to basics. I go back to fundamentals. And I say, look, let's say I was drafting this matter. Let's say there was no brief and the client came to me. How would I position this matter? How would I pitch it? I then allow my, mind unfettered, unencumbered by the brief to formulate how I would pitch the matter. And then I worry about the brief. So absolutely right. You must think beyond. And it's only then that you can be creative. Only then that you can come up with a thought which is out of the box, right? And that's when you add value as a counsel. You come up with something. That's why, you'll hear about the big names and somebody will tell you that, it was magical. We told him X, he went to court and he just pulled a rabbit out of the hat and we don't know how he did it. And, it's just, it's like witchcraft. We don't know. We don't understand. It's a spell. It's not. It's just a method. And if you learn that method early, I assure you, you'll see things that others can't see.
Thank you, sir. There's another interesting question which every one of us after passing a law college would have had in their own mind. So this is Kirti Kokar. She asked for a student, from a student's perspective, how does the impact of initially practicing in a district court different than practicing directly in the High Court or the Supreme Court? Where should a young lawyer start his or her practice?
So as I said in my remarks earlier, there's no formula. There's no prescription, right? It depends on what you feel you are suited to. You can start in any one of those courts and follow a very successful professional trajectory. The Supreme Court is a little different from, say, the district court and the High Court, in that in the Supreme Court, there is no original side work. So most of it, of course, there are writ petitions which get filed, under Article 32, but most of it is appellate work. So it's straight away different from High Court and District Court because you're at the last stage, you're at an appellate stage, it's already been through several stages. And so that experience is quite different. I would certainly recommend that at some point early on, one should have an experience either of District Court or High Court and of original side work, of putting together a petition or a civil suit from scratch, building up that case, because there's a lot of learning in that which you don't get in Supreme Court. So again, you can start out in Supreme Court, but if you exclusively practice there for too long, then you're going to miss out on a particular kind of learning, which you will get in the High Court or the District Court. Again, High Court will have some appellate sort of cases. It's a slightly different experience. There are advantages and disadvantages to both places. The High Court judges will be more experienced at times, tougher at times, but they may be more receptive at times to certain legal arguments. In district courts, there are at times frustrations because certain legal arguments, you find that the bandwidth is not there. At the same time, I have found some extraordinary young district judges who are eager. They are very happy that a counsel from High Court or Supreme Court has come. They try to understand, they try to learn with you. They are open about what they don't know. And it can be a wonderful experience for a young counsel also, because those younger district judges engage with you and they're bright and they are unafraid of saying, look, Mr. Counsel, I don't know this branch of law very well. Please explain to me. That doesn't mean they'll decide in your favor. They are going to decide in depth. So there are gems, real gems of judges in the district courts before whom practicing for a young counsel can be a real pleasure. But it's a bit uneven. It's a bit uneven. That way in the High Court, there's a little more consistency of quality of judges, in terms of receptiveness to legal arguments. Sometimes before district judges, those finer nuances are lost. So I've had experiences where, I'll be arguing and the judge is nodding, and the judge doesn't have that confidence, very frankly, or that understanding to pose those questions to me. So I have no interaction with the judge and I have no idea what's going on in his mind. And therefore it's very difficult. I want a judge to tell me, this is my doubt. But the judge is a bit overwhelmed by the weight of, 20 judgments and legal submissions and so on. And ultimately the judge nods, smiles, reserves the judgment, and then you get the judgment and, you're at a loss and you realize that what you argued, the judge wasn't able to appreciate. So there are those frustrations which are not as great in appellate courts. But as I said, it can be a very enlightening and encouraging experience in all courts.
Thank you, sir. Nitesh, over to you.
Thank you, Angel, for taking up all the questions which have been left up. Sir, I think all the questions have been relatively answered by you on all the points in the queries. Sir, I be taking one question from my side. Being the first generation lawyers, starting the counsel practice, at what years or like after what years of the practice we should go for?
So look, I mean, ideally, and I know that it's not always realistic, it can be very challenging, but beyond 7 years, I feel you are losing time. So up to that is okay. Beyond that, I would suggest take a leap, right? I know it's always daunting. It's, it's worrying, it's intimidating. You wonder, will I get cases? How will I cultivate clients? But, it's always going to be a leap. So if you wait too long, if you spend 10 years without attempting, to become independent. So first thing is that independence. Once you become independent, of course, slowly, you need to convert. First, you'll argue your own cases that you have filed, right? So that's how you'll get arguing experience. And then slowly, you need to move away from that filing counsel identity. And you tell, you get a colleague and you ask him to file, maybe share the fees with him. But, pitch yourself that, look, this is my instructing advocate, I am the arguing counsel. People should get a sense that, look, okay, that's an arguing counsel. If you're filing and you're arguing, then another lawyer will say, look, why should I brief him? If I brief him, my client may go to him because he files also. That's a bit of a problem, So you have to, over time, try to sort of see how you can position yourself that, look, I want to be an arguing counsel, get someone, colleagues to brief you, and slowly, hopefully get noticed.
Can you hear me, sir?
Yes, now I can. Now I can.
So, sir, summarizing the today's topic into 4-5 points, which I have got, is that first of all, as a arguing counsel, we have to grab the opportunities to argue, and we have to create those opportunities for us by taking the chances whenever it comes to our plate. Always been ready to argue. Generating goodwill amongst others is definitely a good formula to generate the counsel practice. Don't aggress ourselves and not to engage in the personal crossfire when a senior is arguing opposite to you. So with these formulas, sir, I would like to thank you on behalf of our board today. We are lucky to have Mr. Akhil Sibbal, sir, today, who has spared his precious time with us and for having us given this undivided attention on such crucial topic. Sir has spoken candidly on the aspects of preparing oneself with the instincts of an arguing counsel. This was the very purpose of today's webinar, and we are indebted to Sir for having us readily agreed to take up the session with us on this candid topic. I would also like to thank the IIMT Law College and Dr. Pankaj Dwivedi, the Director of the Law College, who has joined hands with us today in collaborating the today's webinar. So with the bottom of my heart, sir, I once again thanks a lot to you, to Mr. Angel Bhardwaj, who was there with me on the board, Mr. Anand Garg and Dr. Amit George. Thanks a lot to all of you. With this, we are ending and concluding today's webinar.
Thank you, Nitesh. Thank you, Nitesh. Thank you, Anand. Thank you, Engel. Thank you, Amit. Thank you all.
Thank you.